Have you ever wondered if you are entitled to an inheritance and you haven't heard anything about it? Have you ever wondered what you do about it? And I think this is one of the age-old questions on what to do if you don't get your inheritance. And I'm doing this because we see it a lot in our practice here at GQ Law, and they are the sponsor of today's show, by the way. The some of the challenges that we end up seeing is we see a lot of people that haven't gotten their inheritance, and we're trying to figure out why. And part of what we're going to be doing is, as we go on to the show, is I'm going to have my paralegal Lorena come on and talk to us about this kind of stuff too. So let's see, make sure I get all my levels okay here. There we go. All right. So first of all, when someone passes away, a lot of times what beneficiaries want to do is they think, well, if the big brother is the successor trustee and the little brother and little sister are the ones that are just supposed to receive their inheritance, that they can just all sell all the property, divide it all up in equal shares, and hand it out. And that may seem all fine and good. In fact, some people, they can kind of pull that off. But then when they talk to me, it's usually because there's some issue. A lot of people who think that there's nothing wrong with the estate, everybody gets along splendidly, and we're willing to just divide things up in equal shares. That seems like the way to go. However, there's some requirements under the California Probate Code that governs all property of decedents. So anybody that passed away, whether they have a trust or a will or nothing at all, they are still controlled by the California Probate Code. And I know we've been told, oh, probate is a bad thing and avoid probate and do a living trust. The probate that we're talking about trying to avoid when we're saying to do a living trust is the whole probate petition process, where we actually are petitioning a California probate court to ask a judge to make a ruling or a decision on a particular piece of property or on the estate in general. So when I say the California probate court has jurisdiction, I mean that any disputes, any issues, any questions, any problems, anything we need to know about the trust or about a will, that's under the jurisdiction, the power or the authority of the California Superior Court Probate Division. In court, there's several different types of Superior Court. Okay, so you have Superior Court Civil Division, and that's where people do lawsuits against each other. You have a plaintiff that is suing somebody else that is called a defendant, and they have disputes over property rights or money rights, or that somebody was injured or wronged, that type of thing. That work is called tort work. Tort, not like, something you eat from a bakery, but a tort meaning a civil wrong. Also, you have contracts and things like that that get managed in civil. Okay, that's one division. Another division of the California Superior Court is family law. That has to do with divorce, separation, child support issues, property division. Those have to do with the family court issues. Okay. Then you have criminal division. Criminal has to do with bad guy, bad gal versus the people. So usually the person that's doing the prosecuting or that's going after the criminal is the people. So you have a representative like the district attorney or the U.S. attorney or somebody that's representing the people and going after the violator, the one that violated the law. That's criminal court. Usually penalties as a result of criminal court, there's going to be usually it's jail time, lack of, loss of freedom, those type of things. That's criminal. Then you have probate. Probate court is another division of the California Superior Court. Probate court deals with people that can't do things on their own because of incompetence, because of lack of capacity. And the incompetence may be legal incompetence, meaning they're under 18. They're not legally competent to make certain contracts or agreements. Or it may be legal incompetence because of an incapacity or a mental disability or something like that. And the other thing is that you may not be able to make choices or decisions on your own because you're dead. So probate court deals with guardianship issues, of minor children, right? Those are incompetent people, considered legally incompetent, are minors under 18. Then you have adult incompetence. So that might be a conservatorship or an issue regarding conservatorship, conservatee, conservator. And the other thing is people that are deceased. So that's going to be dealing with estates and trusts and things like that. So when I say the California Probate Code controls the property that's in your living trust, or that controls, whether you have got your stuff in time or properly, or whether it's been accounted for, or whether there's any damages, all of that stuff has to do with the probate code. Probate code has jurisdiction. Okay, back to the beginning of the story. Brother, sister, they decide mom and dad pass away, and they just decide to start dividing stuff up. There's 3 of them. So they take the savings account, they divide it in 3. They sell the house and divide it in 3. They have a retirement account, it's divided in 3. That's ultimately what's going to happen. But under the California Probate Code, it says that the successor trustee now is responsible for taking care of certain other legal things. One being all creditors need to be paid. Creditors have a priority higher than a beneficiary. So creditors need to be paid first. Okay. One of the creditors might be the Department of Health Services. The Department of Health Services is required to be notified. So that's done electronically. We do it through email. It can be done through mail. There's different ways to do it. It's kind of becoming updated and more modern. And by the way, if you want to ask me questions on the air about these things, I'd be happy to take your calls. 888-344-1170. 888-344-1170. If you have any questions, if you're dealing with an issue where you're the successor trustee, or maybe you're a beneficiary, or there's some question you have regarding an estate where somebody's passed away and now you're trying to figure out who gets money and how fast and whether their job's being done right, call and be part of the show. You can just ask me on the air. I'll answer your question. 888-344-1170. 888-344-1170. And if you don't want to ask me on the air, you can always ask me off the air at my office, which is GQ Law. The number is 855-500-TRUST. That's 855-500-TRUST. Okay. So as a successor trustee, the person who has the job of making sure that things get distributed, handed out, paid out, gifted, whatever you want to call that, the one with that responsibility in a trust situation is the trustee. So when you choose your trustee, you got to make sure it's somebody that's going to do what you want them to do. So the trustee's job then is to act as a fiduciary, which has, this real high responsibility level of fiduciary, meaning the fiduciary's job as the successor trustee is acting as a fiduciary. Okay. That person has the responsibility of making sure that the trust doesn't lose value. They're not in charge of trying to invest everything wildly and make all kinds of money and put it all in equities or whatever. They're not in charge of that. They're in charge of preserving the estate assets, preserving what is in that trust, and making sure, if they can, to the extent that they can, that there's no loss of value. That means if something is sitting in stocks or all like in equities, they probably need to roll it back. And so you're going to have a financial advisor to help you do that. Okay. So that successor trustee now that has the job to do the distributions properly, according to what it says in the trust document, that person has the responsibility of making sure that all creditors get notified, including the Department of Health Services. If it's not done and the Department of Health Services comes back later, and they can come back a lot later, 6, 8, 10, 12 months later, and say, hey, there's a $13,000 reimbursement claim here, a $20,000 hospital bill that was paid by the Department of Health Services. Maybe it was a mistake, maybe it wasn't, but who are they going to go after? All the money's been distributed, it's been dispersed by that trustee. Who do you think the Department of Health Services will go after? The answer is, yep, you, the successor trustee. You're going to be the one responsible. So you would then think at that point, well, if as a successor trustee, I had to pay back some money to the Department of Health Services because I forgot to ask them whether they were going to make a claim, I'll just go back to the beneficiaries and say, hey, beneficiaries, give me some money back. I overpaid you. The beneficiaries can say, nope, not our problem. That's your problem, successor trustee. So you got to do your job right. That's the bottom line. You get it done right. You get the right notifications out. You deal with the creditors properly. All that gets done. The idea and what you need to get accomplished is you want the estate to be distributed just exactly like it says in that trust. And it has to be done according to the law. And if it's not, you as a successor trustee could be in trouble. If you want to be part of the show, ask me a question. I won't embarrass you. You can even use a fake name if you want. 888-344-1170, 888-344-1170. To learn about your responsibilities, what you're supposed to be doing as a successor trustee, call me off air, 855-500-TRUST, 855-500-TRUST. What we've also got at GQ Law is we have a website, gqlaw.com. GQ like Gary Quackenbush, law.com. And at gqlaw.com, we have free books called Living Trust Basics. We're giving it for free for the rest of the month. And that's called Living Trust Basics to help you understand how living trusts work. So we're going to take a quick break. And when we come back, I'm going to have Lorena Leroy, my paralegal, and she's going to be helping us out.
From San Diego, this is the Word on Wealth Financial Network. Call and ask your questions about effective stewardship in your family finances, business, and retirement.
Hello again, friends, and for years I've been telling you about Jim Robison, the Medicare Answer Guy. Not only do you hear him regularly answering your questions on the Word on Wealth, but he's also my go-to guy for my very own Medicare questions.
Thanks, Marty. Today, people are wondering if they're making the right decisions about their Medicare and whether they're paying too much. When your 65th birthday approaches, you can count on one thing. You're going to be bombarded with Medicare ads and solicitations. My goal is to save you time and money and give you peace of mind of making your Medicare decisions. I'm local and accessible and just a phone call away. So you can relax in knowing that you'll have the Medicare plan for yourself and for your family that fits your financial needs.
Call Jim Robison, the Medicare Answer Guy, at 858-935-9120. That's 858-935-9120. Tell him Marty sent you. Learn more online at themedicareanswerguy.com.
From San Diego, this is the Word on Wealth Financial Network. Call and ask your questions about effective stewardship in your family finances, business, and retirement.
You're live.
All right, welcome back to the Word on Wealth. This is Gary Quackenbush and Lorena Leroy. Hey, Lorena, how you doing?
Good. How are you?
Good. So Lorena is your mic okay?
Turn it up.
All right. So Lorena is one of our paralegals here at GQ Law, and we wanted to bring her in because she's been on the show with me before, and we're talking about trust administration today. So in the first segment, we talked specifically about, we're kind of going down our checklist at the beginning. Lorena's job, when I say that the successor trustee's job is to do A, B, C, D, E, what I really mean is that when you hire a firm like ours, Lorena is really the one that's going to be doing all this kind of work. So I wanted to bring her in specifically to kind of, so you guys can have a perspective on this type of thing. So Lorena, one of the things that we help clients out with a lot, and it just seems like they kind of miss this, is we hear a successor trustee that says, oh no, I've taken care of everything. And my brothers and sisters, we're just like really good with each other. And we've given everything away and there's nothing left. What do I need to do? So, and I know that's one of those things you think about, well, you kind of messed up and didn't do all the things you're supposed to.
Yeah.
So why do we have to do things like deposit the will and notify the Department of Health Services and stuff like that?
There's just a lot of legal requirements that go into trust administration when someone passes away. It's not as simple as, like you said, people think, oh, well, we liquidated everything and we just distributed it and we're good. Everyone agrees. But there could always be a problem where one of your siblings is not okay with everything.
Turn her up, Gary.
and they could come back and, request certain things. And you
Mhm.
just always want to make sure that you've done everything in a proper and legal way, so that if you are in that position, everything is done correctly.
And so we've had one of the things that we've been doing, and this is what Lorena and I kind of work with every day, is when things aren't done right and everybody's happy, you really don't notice. But it's like my mom always used to say, it was funny. She'd say, my siblings and I, we'd be fighting or throwing each other around or throwing things around the house. And she'd say, it's all fun and games until someone loses an eye. And then inevitably there would be broken glass or somebody'd be cut or there'd be bleeding or something like that. And then my mom she wouldn't even be mad at us. She just goes, I told you, it's all fun and games until someone loses an eye. And I feel so much of that when we do the trust administration work, is it's all fun and games until someone does something wrong. And that's usually when we get brought in. And what is the first thing, like we got petitions in the last couple of days. I mean, what is the first thing the beneficiaries do to go after the successor trustee?
Usually they want to see an accounting of everything that's been done with the assets in the trust.
Right. They want, I mean, and it's not even like, I mean, they want the trustee to do an accounting and to show what was done, but that's just a legal requirement.
Yeah.
That's the thing that's interesting, is that when people are attacking you or coming after you as a successor trustee, it's not like they're coming up with these wild ideas and saying, we want him chased from the state. They're usually saying, we want him to do his job. And many times the job just isn't being done. And so our job is to go in and kind of get the job done. And it would be nice to have done it in the first place, but I guess then we wouldn't have a job, right?
Yeah.
Yeah.
It works for us.
Yeah, it does. So, but of course, you listeners, obviously your job isn't to employ us. Your job is to stay out of an attorney's office. But I would say, and let me know if you agree with this, Lorena, I think being a successor trustee is one of those jobs where you can't stay out of an attorney's office. You really need help.
Definitely. Yeah. Because there are a lot of things that people don't know. Like you said, notifying Department of Health Services, depositing the will, sending out notifications to the beneficiaries. A lot of people are like, oh my gosh, I had no idea that you guys do all of this, that I have to legally do all of this.
So wait, if my sister was disinherited, I have to tell her?
Yes.
Okay. Now, and that seems like, that seems counterintuitive. It's like, well, wait a minute. But mom and dad decided that sister fell off the rails a long time ago, kind of disclaimed anything to do with the family. And now we have to notify her what's going on. And we have to notify her what's happening with the trust. The answer is
yes.
Why?
Because she has a right to know what's happening with the estate, even if she's disinherited. It is her opportunity to come back, or, she's just entitled to know.
Mm-hmm. Exactly. And that's the thing where you think everything is fine. Well, we just won't notify her. So here's the crazy thing, you guys, is let's say you decide as successor trustee, sister's disinherited. It says right here, we're not going to tell her. We don't need to tell her anything. We're not even going to tell her about the funeral. And you go and do the distributions. The rest of the siblings are all happy. And they go, well, we know that, our sister was a bad egg. And so mom and dad didn't want her to have anything. So we're just going to move on without her. And then sister finds out later, oh, wait, nobody told me mom and dad died. Yes, I've been out of contact, the black sheep, maybe even shunned by the family, whatever. And now she comes back and says, hey, wait a minute. You mean you did distribution and I didn't get notified? Then if she's smart, she'll probably go to court and go after the trustee for basically doing a bad job. And I don't know if she'd get anything, but I mean, it sure looks suspicious.
Yeah.
When that happens. She's entitled to know. I say she just because we're just saying she, not she's, not that all disinherited people are she's, but so we got that established. Now, one of the things I want to talk about this accounting, because Lorena, we run into this a lot. And you guys, I want you to understand, Lorena is really the one that she does the lion's share of all the accounting. I'm usually just looking at it and going, okay, that's right. But when we're doing an accounting, I think a lot of people think, they say, well, Gary, wait a minute. my mom and dad had a trust, and that's supposed to make it so we don't go to probate and everything is really easy. What are you talking about accounting? Can you explain a little bit, like, what does that really mean? What is the accounting involved? Why do we have to do it?
So we need to show the beneficiaries what was in the trust and what was in the estate when mom and dad passed away.
Okay.
So we start, did they have a house? Was it sold? We want to see the bank statements when they first passed away. We want to see all the money and assets that they had. And then we want to just account for everything that was spent. We want to see what the successor trustee was spending money on, make sure that it's a legitimate expense against the trust. And then at the end, we show the beneficiaries, okay, here's what we started with, here's what we spent, and here's what's left for distribution. Do you guys all agree with this or not?
Okay. So the person that is actually doing the accounting or is responsible for the accounting is the successor trustee,
Yep.
right?
Yep.
So what you're doing then is you're helping that successor trustee do their legally required job. We're not making this stuff up. So in the accounting, what would you suggest to a successor trustee, somebody that wants to know, mom and dad recently passed away, what should they start doing kind of like right away in order to kind of prepare for the day when they're going to have this rendering, this accounting?
I would definitely get bank statements, invoices, bills, keep track of everything that you spend and everything that you do. Receipts are great because we ask for those. We want to make sure that, like I said, every single penny that you spent is justified. So just keep track of everything.
So you're talking about things that people don't normally keep. I mean,
Mhm.
when you run a small business, it's normal to keep receipts for everything. You keep your gas receipts, you keep, receipts for expenses and all, because someday it's a deductible expense and I got to prove it maybe. As an individual, I mean, Lorena, do you keep track of your grocery bills? Do you keep your receipts?
Nope.
Because the thing is, it's not deductible. No one cares, and you're never going to have to prove it to anybody, really, unless your dietitian's like insane and wants to know. But it's like, when you become a successor trustee, it doesn't matter that you're not used to, collecting receipts. Now, everything you do is, quote, business related, and everything you spend, everything you touch, the time that you spend, the bank accounts you open, the checks that you're writing, all that stuff has to be proven. And it's not a what if. It's not a, well, what if the IRS audits? It is literally, it's going to be audited by us, by the other beneficiaries, potentially by the court. It has to be perfect. So have you ever had somebody that basically, I mean, I know the answer to this, but it just seems unreal. But like, we'll have sometimes somebody will come in and they've been the successor trustee for like 3 years. There's just kind of some lingering stuff going on. They can't quite sell the house. They don't know what to do. How do you go back for somebody that we want to do the accounting and we know we need to do the accounting, and then they haven't kept receipts for like 3 years? Like, what do you do?
That's really tough. And that actually happens a lot. I'd say a really important one is bank statements.
Okay.
Because that's going to show what expenses and charges you've made. And then if there is a home and you sold it, we need that closing statement. So just it's so helpful from the beginning. If you can just start organizing everything, it is really hard to work backwards.
And it's like, so let's say somebody comes in and isn't the last 6 months good enough?
No.
Okay. So we got to go back to day to death,
Yeah.
Literally. Okay. And so if we have a situation where we don't have bank statements, there's been spending going on for 1 or 2 or 3 years, can the trustee just say, I just don't have those bank statements?
No, we're going to have to figure out a way to get all of those bank statements and receipts, because the beneficiaries are entitled to see what you've done. So we're just going to have to figure out a way to make it happen.
And the thing is, where the importance of the accounting, the reason we're emphasizing this is because before the beneficiaries get like the last distribution and settle the entire estate with that successor trustee, before that happens, you guys listen up, that successor trustee needs to have approval of all of the beneficiaries. Now, not a disinherited beneficiary, because they don't have to approve. They've been disinherited. They had their rights to object and all that. But the beneficiaries have a right and they have the obligation to sign off on that accounting, showing where all the money was spent, where, how much was in the account, how much is left, how much they're getting. They have to sign off. If you make final distributions as a successor trustee and you just write checks to all the beneficiaries without them signing an agreement, that's actually not proper. That's a violation of your duty as a successor trustee, number one. Number two, how do you know if your job was ever done if you're not being released from your duties? The way to get released from your duties and to be done as a successor trustee is you either have to get all the beneficiaries to agree that the accounting was done properly and that they're satisfied with the amount of money they're receiving, or number two, you have to go to probate court. So you have to petition the probate court and say, Judge,
1 minute.
This is the trustee. Judge, here's the accounting. Here's all the money that was accounted for. Here's what was spent. Here's where it came from. Here's the value of the house and the properties. And you have to get a judge to look at it and approve the accounting. How easy is that, Lorena?
That is not easy.
It's so hard because it's like they are so particular. So if you are a successor trustee, you need to, as soon as you know you're doing that job because you get a copy of the trust and you go, oh, wow, Dad trusts me to be the trustee, start collecting information. Don't throw anything away. You've got to just collect it, because eventually, to settle the estate, you're going to have to get everybody to sign off and either agree
30
that
seconds.
the accounting is exactly right, or you're going to have to go back and get a court order. And that's one thing we do quite a bit here at GQ Law. So if you want help with that, if you have questions on that, if you're in the middle of it, if you're going to start on it, give us a call, 855-500-TRUST. That's 855-500-TRUST. You can also go to our website, gqlaw.com. That's gqlaw.com. So give us a call, 855-500-TRUST. Go to the website, gqlaw.com.
10 seconds.
We're up against a break. And when we come back, we're going to talk to Lorena. We're going to ask some questions about how do you fight a trust.
From San Diego, this is the Word on Wealth Financial Network. Call and ask your questions about effective stewardship in your family finances, business, and retirement.
With SRN News, I'm Jason Walker. With the situation worsening, the Biden administration taking key steps now ahead of a possible Russian invasion of Ukraine.
In response to rising tensions in and around Ukraine, the State Department ordered the families of all American personnel at the U.S. Embassy in Kiev to leave the country. Americans are also being warned against traveling to Ukraine and Russia. Meanwhile, President Biden met with his national security team over the weekend to discuss diplomatic efforts to de-escalate the situation, but also other options to confront Moscow if there's an invasion.
That is White House correspondent Greg Clugston. In Milwaukee, police finding 6 people dead in a house. Dead include 5 men and 1 woman. Military police fatally shooting a man who breached the main gate at Kentucky's Fort Knox and tried to run over the MPs. The Army continues the investigation. This is SRN News.
From San Diego, this is the Word on Wealth Financial Network. Call and ask your questions about effective stewardship in your family finances, business, and retirement.
Hot mics.
Welcome back to the Word on Wealth. This is attorney Gary Quackenbush and Lorena Leroy, my awesome paralegal here at GQ Law. You're awesome, right, Lorena?
I like the things though.
That's fun. So Lorena is one of those kind of people that loves doing this stuff, which is why we love Lorena here. So we are talking about some things, and some of these things we're going to talk about are legal type issues. So we're not giving legal opinions. I just want you to hear it from, we're in the trenches doing this kind of thing. And I thought I would ask Lorena some questions. Fighting a trust. We hear so much that, if you fight a trust, you're disinherited automatically and things like that. But talk to me about that a little bit, about the trustee. There's something that the trustee has to do at the very beginning that almost seems like she's actually kind of asking for it.
Yeah, at the beginning, the trustee sends out a probate code notification, and it lets the beneficiaries or the heirs know that there was a trust, this person has passed away, and you have 120 days to contest the terms of the trust.
Okay. So it almost seems like at that point, the trustee's saying like, bring it on. If you got any objections, it almost seems like, well, why would you do that as a successor trustee? It seems like, why would you kind of want to stir up trouble?
You legally have to.
Okay. That's right. I don't care if you want to. I don't care if it sounds like a good idea or fun. It's legally required. It's one of those things. Now, another legal requirement that just seems so weird, and that is depositing the will.
Yes.
So what is depositing a will?
So depositing the will is we actually send the original will to the court to get what's called deposited. So they just keep it there at the court in case we ever need it. They have it.
It's public record.
Yeah.
And why do we have to deposit the wills?
In case we need it for the probate court.
Okay. And if we don't, then
just kind of lives there.
it just lives there. Yeah. And the thing is, and if you don't deposit, if you have a will and you don't deposit it, you may be thinking, oh, who cares? Who's going to notice? Well, it's one of those requirements. And one of the things that we see, if you have a beneficiary now that's a little annoyed because things are taking longer than they thought, or maybe they thought they got to make a decision, right? I mean, beneficiaries always think, well, yeah, our sister is the successor trustee, but all 6 of us get to make those decisions and we have equal power. True or false?
False.
Okay. The successor trustee has all power. That sounds pretty ominous. But the other thing the successor trustee has is all responsibility. And that's why you do your job right. So depositing the will, doing the probate code notifications, if you don't do them, then you have broken 2 laws. One says you have to deposit the will within 30 days. The other one says you have to do a probate code notification. And the other one says if somebody asks for an accounting, you need to provide an accounting within
60 days.
60 days. And that may seem unfair. Oh my gosh, that seems so unfair. But that's the law. That's the rule. So if you have asked your successor trustee, hey, I'd like to know what's going on. I'd like to know where the money's been going. I'd like to know how things have been spent. That's called a demand for accounting. And that means if you do it officially, they've got 60 days to respond. If you're a successor trustee and your siblings have said, hey, we want to know what's going on, brother, then you got 60 days to come up with those numbers. And if you don't, you have broken a rule, which is accounting in 60 days, if demanded, reasonably demanded. I mean, the beneficiaries can't do it every day. They can't do it every couple of months, but they can do it a reasonable period of time, which is typically in about a year. About every year, they can ask for an accounting. The other thing is if you didn't deposit the will, that would be like strike 2. And then strike 3 might be you didn't do the probate code notification. So the way we handle that, and I want Lorena to explain this a little bit. If somebody comes to us, like let's say a beneficiary comes into GQ Law and they say, mom and dad passed away. It's been like 2 years and I haven't received anything. I don't really know what's going on. I know mom and dad had a trust. They said everybody's going to be treated fairly. What do we do in that situation when somebody comes in with that problem?
Normally, we'll kind of start with a softer approach by sending the trustee a letter, just saying, hey, kind of checking in, what's been going on. And that's usually when we'll demand an accounting from them as well.
Okay. And so we kind of like, it's kind of like we're prodding them and saying, okay, because a lot of times the way our letter goes is like this, is we say, hey, being a successor trustee is a big deal. Kind of like, congratulations for stepping up or being named. You have some obligations under California Probate Code 17200. You're required to do this. And under this code section, you're required to do this. So basically outlining what the successor trustee job is. And then we say, so we'd be happy to kind of sit back and wait for you to comply and do this legally. Or if you need some help, let us know. That's kind of our semi-soft approach, right?
Yeah.
And then we're pretty successful when that happens.
Normally.
I mean, sometimes people respond, The best one I like is when somebody comes in and next thing we get is a letter from their attorney.
Yeah.
That's
normally what happens.
Yeah. And that we like because then we know that the successor trustee has finally hired an attorney and hopefully the attorney knows what they're doing. Not always the case. I looked at Lorena and she went like, not always. Not always. So assuming they know what they're doing, we're happy to kind of coach them along. But that's the thing. So doing your job right is important because if you do too many things wrong, let's talk about that. So I want to give you our number again, 855-500-TRUST, 855-500-TRUST. If you need help being a successor trustee, we do that, Successor Trustee Coaching Services, and we'll do all the work for you and help you out. If you have questions as a beneficiary and you're trying to figure out what is going on because you're not getting you're not getting your distributions like you're supposed to be getting, then you can call us also 855-500-TRUST and we help things get settled. All right. So Lorena, the one thing that I guess what happens ultimately, let's say that, we tell the successor trustee, hey, here's your job. Here's what you're supposed to be doing. And then the successor trustee basically does to us like they've done to their sibling. They don't do anything at all. What's next?
We could send another letter, just reminding them that you do have a legal requirement to do these things. If we still get no response, that's when we take a little bit more aggressive approach and probably file a probate petition to get them to do their job. And if they don't want to do their job, then let's try to name someone who will do the job.
Right. And that's kind of the goal, is if they don't want to do their job, we want them out. Not that that's a bad thing that they want to be out, but if you're not doing your job, get out. That's, that's the thing. So we go with a petition and we're really, in the petition, what are we doing? We're saying we want an accounting and we want to name a beneficiary or a successor trustee that's going to do their job. And oh, by the way, there was no probate code notification, which is that 120-day notice we just mentioned. And oh, by the way, the will was never deposited. There's just all these different things. And then we go to court and now we're getting a judge involved. So the idea in court is that ultimately kind of the end of that process is that you're going to be in a trial, having a judge make some orders and determination. You don't have to wait until trial. You can get the judge to do some orders in the meantime, but the judge is basically saying, thou shalt do this, thou shalt do this. And if the trustee then doesn't respond, then he could be in contempt of court. And now you're in a different division. Now you're getting into some criminal activity because you have to do what the judge says, the bottom line. So Lorena, in these cases where we are petitioning the probate court, we're going and we're trying to, basically compel the successor trustee to do an accounting, compel the successor trustee to give us the documents we're asking for. How often do those actually resolve before we go to trial?
It's not super common that it gets resolved. Ideally, we would like to get everything resolved. But it's a very slow process, and it's, from what I've seen, doesn't really happen.
Yeah. And that's the unfortunate part, is it really, once you get going in court, it just seems like they just get more expensive and they get a little more cumbersome and people get a little more stubborn. They typically do settle, but sometimes you end up spending just so much time and energy and effort, emotional, wear and tear to get to that point. I just think it's really worth considering, if you are a successor trustee and you think you're doing a good job, is get somebody that knows what they're doing. Don't do it yourself. If you're a beneficiary, maybe as a beneficiary, you think, oh my gosh, if I hire a lawyer, then I'm being a total jerk because now I'm questioning my brother's integrity or my sister, whoever's being that successor trustee. Maybe you think you're being a jerk, but let me tell you, the longer it goes, the more crazy expensive it gets. And by that, I mean, when mom and dad pass away, you have Prop 19 to deal with, because when they pass away, the property taxes go up. And that's the only exception to that is if somebody moves into the house and it's their principal residence. But property taxes are going up. You have to deal with insurance. You're going to have to deal with, other types of taxes, tax returns for mom and dad. Those things have to be done. Those are all legal requirements. And so the longer you wait, the more it costs in time and fines and fees and penalties. And all that stuff has to be paid by somebody. And I think if you're a beneficiary and it's not being distributed, like it's not moving forward, you haven't heard anything, it's been 6 months, you're doing that successor trustee a favor by pushing them to get it done, because the courts are not sympathetic to successor trustees who don't do their job. They're just not.
1 minute.
The successor trustee wants it done. I'm sorry, the judge wants the successor trustee to do their job, and they want them to do their job right. And there's very little forgiveness. A judge isn't going to say, oh, that's okay. You wasted a lot of time and you caused, a $5,000 penalty and this tax is now due. And had you done it right, this wouldn't have happened. The judges are not very forgiving of that. So you want to make sure that you know what you're doing and you get moving forward. So if you're a beneficiary and you're worried about like going after a sibling as a successor trustee, don't worry about it.
30 seconds.
Just get somebody that's going to help them move forward and get their job done. And if they don't want to do their job, that's fine. Totally get that. If they don't want to do their job, then they can step aside and somebody else can do it for them. And you can get professionals too. We're going to talk about that. We're going to take a quick break and we come back. We're going to talk about professional trustees. Give us a call at 855-500-TRUST. That's 855-500-TRUST. And let us help you with your trust administration distribution. And we'll be right back.
From San Diego, this is the Word on Wealth Financial Network. Call and ask your questions about effective stewardship in your family finances, business, and retirement.
We're with Craig Smith of Borderland, your local source for cybersecurity. And Greg, what are you seeing today in terms of ransomware attacks?
Well, employers of all sizes are wondering which employee will it be? Who will be the one that clicks on that phishing email that brings my company to its knees with ransomware? Clicking on what seems like a safe email can allow hackers to load viruses, steal your passwords, and watch what you type, ultimately stealing data. And once this data has been extracted and backups encrypted, ransomware shuts down one computer at a time in your business, and by then, it's just too late.
So, Craig, how can you help?
Well, our team, our local guys at Borderland, educate your staff. They use state-of-the-art hacker training programs, and we set a perimeter around your business. Don't be shut down by hackers. Protect yourself for only a few dollars a month per employee.
Call Borderland right now at 855-945-8100 and get a free consultation and quick quote on software services that help protect you and your small business. That's Borderland, 855-945-8100.
We look forward to protecting you.
From San Diego, this is the Word on Wealth Financial Network. Call and ask your questions about effective stewardship in your family finances, business, and...
You're live.
So we said we would talk about professional fiduciaries, and that's what Lorena and I are going to do. When you have a successor trustee, that's always the person that is managing the trust after, for example, mom and dad have passed away. So that's the successor trustee. Or it could be after mom and dad are both incompetent. They can't make any legal decisions. They're in assisted living, or they've got, full-time care or something like that. Then whoever's managing the money could be the successor trustee. Sometimes you get a situation where the kids are not happy with distributions. They're not happy with the accounting. They're not happy with things. And they, so they're going after their sibling, basically saying, you don't know what you're doing. We disagree. So we would go to court, like Lorena was saying, we go to court and we explain to the judge, we want an accounting approved, or we want a new trustee, we want an accounting, all these different things. And sometimes what the judge will suggest, rather than have another sibling like step in place of the sibling that's doing a bad job, sometimes the judge will suggest that we go with a professional fiduciary, a private professional fiduciary. And there's a couple of organizations in San Diego that, or Southern California, actually they're all over California. There's an organization that we particularly like, and that's PFAC, Professional Fiduciary Association of California, PFAC. And PFAC is a big organization where if somebody wants to be a professional fiduciary, then they sign up for PFAC, and then they have continued education requirements so that they're updated on the new laws and all that type of thing. And what happens is the judge says, we want somebody to be picked a private professional fiduciary. And then the judge will actually give us time, sometimes it's a month or two, to go and interview private professional fiduciaries to see who we like. And then both of the warring parties, the one that's bringing the motion and the one that's defending against it in probate court, they're going to come to some type of an understanding or an agreement. And if you can agree on a private professional fiduciary, the court will actually order them to do the work. Now, the private professional fiduciary, they're going to get paid the same amount of money as your kid brother would have got paid, or your kid sister, because trustees don't work for free. It's just way too much work, too much time. So you get a private professional, it doesn't really cost that much more. They are much more particular about things. They're not, they don't have the family in mind. They're just simply doing their job and preserving the trust assets. They don't care about your bickering. They don't care about your disagreements. They're trying to preserve the trust assets and do what the trust says. So if you want flexibility, agree with your siblings, agree with your successor trustee sibling. Don't try to push a successor trustee professional around. So that's one kind of professional fiduciary, is a private professional. And the other one is like a bank. So you could have Wells Fargo, and I'm not endorsing any of these. In fact, I'm not particular anyway. But like Wells Fargo has Wells Fargo Trust Services. There's different big banks have their own trust services. Usually their fees are really expensive. They're like 3 to 6% of the gross amount in trust every year. And a lot of times they won't touch it unless there's, $3 or $4 or $5 or $6 million in the trust. They all have their limits. So usually when you get big institutions like banks, they don't want to touch it unless it's like really, really big and they can make a lot of money. Private professionals are not terribly concerned with how much money's in the estate. I mean, if you got, $100,000, nobody's going to touch it because there's no reason to. It's just there's not enough money there. So banks are another one. The other one is an institutional fiduciary, which you have organizations like, for example, like Schwab, just throwing that out there. They have Schwab Trust Services, and it's and so they actually will provide successor trustee services for a fee. And they have a chart that'll show, if you have $1 million in your trust, then they're going to charge you, like a 0.7% fee. If you have $2 million, it's like a 0.5% fee. So they have their trustee fee services that they provide, and that's an institutional trustee. So you could name an institution also. This comes up sometimes when we are doing the estate planning and somebody doesn't have a trustee that they can trust. Their brother's too old or too mean or irresponsible. I don't know, but sometimes we end up naming, and we've done that several times where we name like Schwab or Merrill Lynch, and there's different companies that'll do, trust services. But that's just another way to go. They're not, disadvantage is they're not as personal because they don't know the family. As far as flexibility, they're not. That's one of the advantages of them. They're not flexible. So if you have beneficiaries that want to fight about things, the successor trustees, they won't fight. They'll do just exactly what the law says and exactly what the trust says. And then the other, and that's really pretty much all you have to choose.
90 seconds.
If you have let's say you're trusted and you want to give a lot of money to a charity, sometimes the charity will step up and they'll be willing to act as a successor trustee. And we've found that that's not always the case though.
Yeah.
We had one where they got money, the charity got a lot of money and they said, no, we don't want to be the trustees. So it causes some problems. But a lot of times you just choose your charity and say, hey, like if you don't have kids and you want to give money to a charity, ask the charity if they'd be willing to be the trustee. And sometimes they would. And then that kind of relieves you from a lot of, choosing and stuff like that. So Lorena and I just wanted to kind of touch bases on these things. We, trust administration, trust distribution, inheritance litigation, those are all things that need to be dealt with. If you have questions on any of this stuff, get a free consultation with me. The initial consultation is free. 855-500-TRUST, 855-500-TRUST. If you need help being a beneficiary, you need help being a successor trustee, or you need help putting your estate plan together, we do all those kind of things. And we've done it for over 3 decades here in San Diego at GQ Law. So give us a call, 855-500-TRUST, or go to the website, gqlaw.com, and download our free books. And we'll talk to you tomorrow, same time, same station. You're listening to The Word on Wealth with Gary Quackenbush, and today, Lorena Leroy. We'll talk to you tomorrow. Bye, everybody. Have a good afternoon.
Great show, dude.
Thank you.
Have a good one. We'll see you tomorrow.
All right. See you tomorrow.
Oh, I'll reach out to, I forgot. I will reach out to that, the mental health counselor today and see if I have a response for you for Friday.
Okay, sweet. Thanks, Noah.
Thanks, bud.
Bye.